Represent the appellant, father, Mr. David Wade Jr., and I will be referring to him as father throughout the course of my argument. This matter also involves the appellee, Ms. Sarah Boren, who I will be referring to as mother, and the party's daughter, Madeline. This appeal arises from a post-divorce criminal contempt action that was heard in the Circuit Court of Shelby County. Today, I will show you that the court committed reversible error when it found father guilty of one count of criminal contempt and subsequently sentenced him to 10 days in jail. The trial court erred in 3 ways. The first error was finding that father was afforded proper notice as required by Tennessee Rule of Criminal Procedure 42B. The second error was finding that mother met the threshold requirements necessary to support a finding of criminal contempt. And the third error was when the court abused its discretion by reaching a decision that defied logic. Give a brief history. Mother and father divorced in November of 2007. At the time, Madeline was 3. Since then, several petitions have been filed, various orders have been entered. On October 12th of 2020, the trial court entered an order that read, in pertinent part, that father is to cease and desist from communicating with SBA or the Catholic Diocese regarding any matter concerning the minor child, Madeline Wade, including sending emails and making posts on social media. On September 23, 2021, mother filed her petition for criminal contempt and injunctive relief, alleging, in pertinent part, that father violated that provision of the October 2020 order. On November 15th of 2021, mother filed an amended petition, again alleging that father violated that provision of the October 2020 order. In her amended petition, mother alleged that father's posts on his personal Facebook page, where he was speaking out in part about child abuse, a topic of public interest, amounted to communications with SBA and/or the Catholic Diocese in violation of the order. Mother's amended petition is the subject of this appeal. The trial was conducted over 2 days in January of 2022 before Judge Jerry Stokes. At that time, the court heard testimony from 5 lay witnesses and 1 expert witness. Mother introduced 12 posts into evidence and sought a finding of criminal contempt as to each post. The court found that 1 post rose to the level of criminal contempt. That was the Facebook post entered into evidence as Exhibit 4. The first issue is notice. Trial court erred when it found that father was afforded proper notice as required by Tennessee Rule of Criminal Procedure 42B. This court held in the matter of Story v. Story that sufficient notice meeting the requirements of due process must be given as a prerequisite to a court's authority to punish a party for contempt committed outside the presence of the court. Mother's amended petition, filed November 15th, 2021, failed to enumerate the separate charges for which she sought father's incarceration. The petition was confusing. It references a battery of Facebook posts. It lists 22 examples of alleged violations. It attaches 22 exhibits to support those allegations. Then she goes on to say she's proceeding on 14 counts of criminal contempt in the body of her petition and 14 counts of criminal contempt again in the prayer. Mother failed to specifically enumerate which of the 22 examples cited in her petition she intended to include in the 14 counts of alleged contempt.
Does she have to do that?
Well, in the case of McLean v. McLean, this court held that the father was not provided with requisite notice pursuant to Rule 42B in part due to mother's failure to enumerate separate charges for which she sought incarceration.
Are you saying that the instance that the court found your client guilty of contempt was not enumerated in the petition?
It was included in the petition. The issue lies where she listed 22 examples of contempt and said at the end that she would be proceeding on 14 counts without clarifying which of the 22 would be included in the 14. And as a criminal defendant, it should be clear what he's being charged with and what he's being asked to defend.
Did you file a motion for a more definite statement?
No, Your Honor.
Did you ask for any clarification?
No, Your Honor. Mother's failure to provide proper notice resulted in a violation of father's due process, and as such, the finding of criminal.
How?
Because he should be afforded an opportunity to prepare for the exact charges that he is being complied with, and if charges are being dismissed, the burden is on the petitioner to dismiss those charges.
Did you object to that at trial?
At trial, only 12 counts of contempt were ultimately put forward, even though they had submitted 14 in their brief. But I did only
an objection raised with the trial court at the hearing.
I did not raise an objection as to them proceeding on those 12 counts at the
You did
trial.
not assert that you were not able to be properly prepared because of notice.
I submitted to the trial court that he was only on notice of those specific counts outlined in the petition,
Which included
Exhibit 4.
the allegation that he was found guilty of.
Correct, Your Honor.
Okay.
The second issue is that mother failed to meet the threshold requirement necessary for a finding of criminal contempt. As this court knows, there has to be an order. The order allegedly violated must be lawful. The order must be clear and unambiguous. The individual charged must in fact have violated the order, and the individual must have acted willfully in so violating the order. The relevant provision of the October order was neither clear nor unambiguous. It is important that I remind the court of the guidance that has been offered by this court as it relates to a finding of contempt. A person may not be held in contempt for violating an order unless the order expressly and precisely spells out the details of compliance in a way that enables a reasonable person to know exactly which actions are precluded. The language of the order is this: the court orders father cease and desist from communicating with SBA or the Catholic diocese regarding any matter concerning the minor child Madeline Wade, including sending emails and making posts on social media. When construed in the light of its usual, natural, and ordinary meaning, it becomes evident that it's all but impossible for father to understand the prohibitions set forth in that provision, and therefore impossible for him to comply. I suggest breaking it into two parts. First part, father is to cease and desist from communicating with SBA or the Catholic diocese. Neither SBA nor the Catholic diocese is a person with whom father could communicate in the first place. SBA is a place, it's a building. It consists of brick and mortar. The Catholic diocese, according to Merriam-Webster, is defined as the territorial jurisdiction of a bishop. What does it mean to be prohibited from communicating with a building or territorial district or territorial jurisdiction? Because of that ambiguity, when construed in favor of the person facing the contempt charge, father, the specific language of the October 12, 2020 order is unclear at best. Second part of the provision, he is prohibited from communicating regarding any matter concerning the minor child, Madeline Wade. A reasonable person would interpret that to mean I am not to speak about my daughter, Madeline. The majority of the Facebook posts entered into evidence referred to child abuse. It does not follow sound logic that a prohibition against father for speaking out about his child would extend to a prohibition against father from speaking out about other children. Father's post, Exhibit 4, did not reference Madeline, did not reference his daughter, did not reference the child he shares with Ms. Boren, and therefore was not a post concerning Madeline, falling within the purview of that order. If the trial court intended to prohibit father from referring to Sandra Morris on Facebook or from referring to child abuse on Facebook, it could and should have said as much. If the trial court wanted posts about child abuse to stop, a matter of public interest, which father feels very strongly about, the court should have said that, but the court didn't. It said he's prohibited from communicating with entities about his child. If the court believes that the language is clear and unambiguous, mother fails the next factor, which is a finding that father did in fact violate the order. The language of Exhibit 4, the exhibit that was found to be contemptuous, reads, Superintendent Sandra Morris weaponizes attorneys against me when I reached out to her about child abuse I witnessed at her school. Hashtag our Catholic culture cover-up. Best quote of the article, the more parents that ask more questions, the harder it will be for schools to retaliate against a lot of parents. Amen. That language of that post does not mention Madeline, doesn't reference his daughter, doesn't reference the child he shares with Sarah Boren, and therefore is not a post concerning Madeline. Father, this is also important, took measures to prohibit individuals associated with the Catholic diocese or with SBA from being able to view his posts on Facebook. Attorney Robert Hutton was the witness whom Exhibit 4 was entered into evidence through. He testified that father took measures to prevent him from being able to access his Facebook posts. Father had blocked Mr. Hutton. What Mr. Hutton testified to doing was usurping father's efforts to cease contact with him by virtue of logging into other people's Facebook accounts, his secretary's account, his daughter's account, to track what Mr. Wade was saying. And then to come in and say, well, okay, well, he's communicating with me. This is catfishing. It's a concept that was explained by the expert witness who testified, Morgan Pettigrew. It is when someone who does not otherwise have access to social media content poses as another to gain access to the content. Father was free to post about SBA. He was free to post about the Catholic diocese. He was free to post about sex abuse. What he was prohibited from doing was communicating with those entities about his child. Another distinction is the use of the word with as opposed to to. He was prohibited from communicating with those entities. That implies you're prohibited from engaging in an exchange. Okay? He was prohibited from engaging in an exchange with SBA to the extent SBA is a person you can exchange with. He's prohibited from engaging in an exchange with the Catholic diocese to the extent that you can, but there was no exchange. He was making posts about issues he feels passionately about on his personal page. If the court were to enter an order, it's akin to the petitioner is precluded from having any communication with the Court of Appeals. What does that mean? Precluded from sending mail to this address, from entering this building, from saying hello in the grocery store to one of your honors, or from posting about general sentiments about the Court of Appeals on his Facebook. It is unclear, and because it is unclear, he cannot be in criminal contempt because it is necessary that the language be clear and unambiguous. This court has held that vague or ambiguous orders that are susceptible to more than one reasonable interpretation cannot support a finding of contempt, and that there must be no reasonable basis for doubt regarding the order's meaning. Ambiguities in an order alleged to have been violated are to be interpreted against the person facing the contempt charge. The Supreme Court in Convalinka provided guidance about how a court order should be viewed. Orders, like other written instruments, should be enforced according to their plain meaning. Thus, courts called upon to interpret orders should construe the language in the order in light of its usual, natural, and ordinary meaning. Litigants are entitled to rely upon the reasonable interpretation of orders and the use of the plain and ordinary meaning standard to interpret orders. This assures that litigants will be treated fairly. Finally, Mother offered no evidence that Father's alleged conduct was intentional or that Father was acting with a culpable state of mind, meaning that it fails the final factor of the Supreme Court test. In the context of criminal contempt, willfulness has two elements: intentional conduct and a culpable state of mind. A person acts intentionally when it is the person's conscious objective or desire to engage in the conduct or cause the results. Generally, the culpability inquiry addresses whether the relevant act was undertaken for a bad purpose. An act is undertaken for a bad purpose when the actor has the specific intent to do something the law forbids. There was no testimony that Father had any intent to do something that the law forbids. He's asking that the order be set aside for costs at trial and fees on appeal. I see I'm out of time. Thank you.
Hear from the appellee.
Good morning.
Good morning.
Excuse me. Good morning, Your Honors. My name is Charles McGee, and I represent the appellee, Sarah Boren, in the petition for contempt that she had filed against.
I think you're going to need to step up just
I
a little
apologize.
bit. There you go.
I represent Ms. Boren, who filed the petition for contempt, criminal contempt that is the subject matter of our appeal today. I would like to address the issue of notice first. The notice that was given to Mr. Wade were contained in 4 different areas. In the summons, it's contained in the summons that provides that he is subject to criminal contempt, he is subject to being incarcerated, and the petition for criminal contempt, the petition itself sets forth criminal contempt. In addition, the judge advised Mr. Wade that he was in violation of the, if he was found in violation of the orders of the court, he would be subject to the number of days that would be determined on how many violations. And in fact, in my petition, we cited that he be found in contempt of 14 causes of action. And it says in there that he be ordered to jail for 140 days. So to state that there were not sufficient notice, we would just simply disagree with. Mr. Wade was given the notice by the pleadings. Now, if I choose not to proceed on some, Mr. Wade should have been prepared to address all of them because he had notice to prepare, and all of these counts should have been under his consideration until such time that they are presented at trial. At that point in time, to reduce down the number of complaints does not rise to a level of failure to notice, so you can defend yourself. I think subject matter, simply put, he knows he should have been prepared. If he wasn't prepared, he should have asked the court for continuance. None of that occurred. And so I submit to the court that the notice argument fails for lack of addressing why he was not prepared to go forward and what specifically he believed he was prejudiced by. Furthermore, they did not object to the proceedings going forward on the number of counts that we were addressing. And so I submit to the court that the notice hearing, the notice argument fails on its face and should be upheld by the court in regards to this proceeding. I would next go to the issue, I think it's the main focus of this presentation here today, or argument today, is the order in the finding of contempt by Judge Stokes. Judge Stokes, in his findings of fact, set forth that it was necessary to consider all the surrounding facts that occurred that led up to the October 12th, 2020 order. And as Judge Stokes says in his findings, they were the subject matter of Mr. Wade posting on the internet, Facebook, statements to the effect that SBA and Ms. Sandra Morris was allowing for child abuse to go forward, and that that directly affected the minor child Madeline. And so that was the basis of the order that he subsequently entered, which specifically says, and my opposing party correctly stated that he should cease and desist from, I'll read it in its entirety. This court orders that father cease and desist communicating with SBA or the Catholic diocese regarding the matters concerning the minor child, Madeline Wade, including sending emails and making posts on social media.
Let me ask you, how does Exhibit 4 violate that order?
Your Honor, we would submit, in the court found that when the posting occurred, that everybody knew, and the public itself and the parents of other students and teachers knows that Sandra Morris is the principal of the SBA. And subsequent, in the post, it specifically refers to reflecting that Ms. Morris was weaponizing attorneys against me and reached out to her about child abuse. I witnessed her school. There's no question what the school is. It's SBA. There's no question that Madeline was there. There's no question that she was being harmed by these. There was 5 witnesses that testified. The principal, Sandra Morris, set forth that teachers did not want her in their class based upon the problems that Mr. Wade had created.
Should the order have been broader, Mr. McGee, if the court wanted to stop the conduct that's now complained of in Exhibit 4?
I don't agree with that, Your Honor. I think specifically what everybody knew was that the postings that had to do with SBA or any of its, with SBA, let me just back up, with SBA that applies to Madeline, and that was the key, that it had the effect of SBA going to the extent that within 7 days, they were deciding whether or not they were going to allow this child to re-enroll in school. And that was her senior year. There was testimony of what detriment that would cause to this child in applications for, subsequent applications for college. There's no question that Madeline was not the problem in this case. Sandra Morris testified to that. Mr. Wade
Let me ask you a very general question here. You are asserting that what we need to do is apply a subjective standard to this.
No, I'm not, Your Honor, because I believe it has to be an objective standard.
Well, if it's an objective standard, then it seems inconsistent with what you're saying, because we're having, as you say, to understand the circumstances surrounding all this and then apply those circumstances.
Well, I'm following.
Hold on just a second, and then I'll let you say whatever you want to say. If it's an objective standard, somebody should be able to take the two statements, lay them down side by side, and say, oh, it's a clear violation. Can you do that in this case?
I would submit that we can through the findings of fact of Judge Stokes, where he specifically addresses the, of course, I've got the wrong one.
Well, if you're having to use the findings of fact and the circumstances of the case, isn't that a subjective standard?
I disagree, Your Honor. It's objective from the standpoint of what the court.
You mean subjective? I suggested it was a subjective.
Yes.
And that's what you're disagreeing with, I believe.
Yes, I am, Your
I'm
Honor,
sorry.
I apologize.
Go ahead.
What Judge Stokes said in there, and then when you apply it to the injunction that he raised, there is no question that you can read what that findings were and objectively apply it to the injunction that he made. And so the order in itself sets forth the standard, which is it's a finding of fact. It's not speculation on the judge. It's not anything of that nature. And so when Mr. Wade understood what the findings were, that he knows that any violation of that would be a contemptible act. And so hopefully I've addressed your Honor's.
Well, how does that square with convalinka then?
Your Honor, I think each and every case is a little bit different when it comes to contempts. There is a provision that in the case of I apologize for slowing this matter down. What the case says is that when you look at the order, you look at the entire circumstance that would apply to the case specifically. So every case has to be on a case-by-case basis. Now, the question I think the court is going to address is whether or not it's ambiguous or not. And we submitted it's not. Judge Stokes made specific findings that it wasn't not ambiguous. And I think that that's where the court's going to address this case primarily. And we submitted it is not ambiguous.
Well, let's assume it's not ambiguous, but explain to us how Exhibit 4 violates the cease and desist communicating with SBA concerning Madeline?
The communications would be stating forth that Sandra Morris weaponized attorneys against me when I reached out to her about child abuse. I witnessed at her school. That's SBA. That's a communication
All right, and
about
where's the
SBA.
concerning Madeline part? Where does that fit? There's no mention of Madeline in that post, is there?
There is not, but the proof was at trial that Madeline was being harmed by these posts. And it was an incessant, as you can see, Your Honor, we set forth 14 claims. That had been the problem in the last proceedings also. There was incessant post that had a direct effect to Madeline. I mean, she was being ostracized by her peers. Teachers don't want her in. She was suffering from the peers making fun of her because of her dad, quote, crazy post. And so the effect on Madeline was devastating in regards to these posts. And then the referral back into the SBA's, the violation, and subjecting her to also more ridicule and ostracization of the children.
Let me ask you one other thing, Mr. McGee. How does the Court of Appeals opinion that was filed in November of '22, which vacated the October 12th order, how does that affect your ability to go forward on any ruling in that October 12th order?
Your Honor, the question, if I understand it right, is whether it's a void or voidable order. A voidable order is in existence at the time of the act, and it was a lawful order of the court. And so the violation itself was subsequently vacated by that court, but it didn't vacate the findings as it relates to the contempt, because the contempt allegedly occurred before there was a vacating of this. He is under the obligation to follow a court order that may ultimately be voidable. The only way that I would submit that he would be able to not address, be precluded from being prosecuted on it, is if it was a void order. And a void order is absolutely where where the order through due process does not exist, and therefore he could violate that order if it was a void order, but that would be at his own risk.
So that order was voided by our ruling, wasn't it?
It was voided, but it's a voidable void, but not a void ab initio. And so there is a distinction in that matter that, and I'll cite to the court, the case of Churchwell versus Callens in the Court of Appeals of the Western District, 36 Tennessee App 119, and it sets forth that a void judgment binds nobody, but a voidable judgment binds everybody, and justifies every act done under it until it is reversed or modified on appeal. In the court, if the court has jurisdiction, what we did, of the person and the subject matter, it is a valid order. Though it may be erroneous, and disobedience the same by a party affected is contempt of court. And so I submit that a voidable order, and that's what the court did, in my opinion, is prosecutable because it was a valid order at the time of the violation.
Okay.
Tell you what we're going to do, and Judge Armstrong raised an excellent point. we're going to give the parties an additional time because this is, could be a very important matter in this case. We'll give you an opportunity to brief that issue. We'll ask both parties to do that within 10 days. Is that sufficient time? The issue of the effect of the Court of Appeals decision on this matter.
Now, may I get some clarification, Your Honor?
Certainly.
Are we both to submit our briefs at the same time, or is it the appellant's obligation first and then I file my reply brief?
My thinking was you would both submit at the same time because whatever effect it has, it's a legal effect, I would suspect. That's what you're arguing anyway. So,
Yes, Your Honor. So I just want clarification
Yes,
on
sir.
that. And will our 10 days start running tomorrow or today?
I will say tomorrow. How about that? That'll
Thank
give
you
a
so
little
much,
bit
Your
more
Honor.
time.
And unless there's any other questions, I submit it to the court.
Okay, all right. You've used your time, and we'll
Judge
hear
Stafford.
from the...
Judge Stafford, I have one other question.
Oh,
if I
I'm
may.
sorry. I apologize.
It's free.
I was lost over here.
Mr. McGee, as I sit here and follow your argument and concerning communications versus social media posts, is it my understanding that you are arguing that a communication with an individual equates with a social media post regarding an individual which may or may not be directed to any certain person?
My communication, I would submit, would be like this. The teacher, and I believe the facts point this out, is on the Facebook, and they read the post in and of itself. That is a communication because the person's a school teacher within that SBA. And so the whole point of the the injunction was to stop that because of the harm that was going on. And so Mr. Wade was well aware of what the facts were in the last proceeding, and these posts, exactly these same type of posts, resulted in this injunction. There were similar posts about Sandra Morris, the principal of SBA, but that was prior to the injunction that was issued that resulted in the issue of the injunction issued on October 12, 2020. And so this injunction was designed to protect Madeline, to protect her from being not expelled, but not invited back, to protect her from being ridiculed from other children, to protect her from parents not wanting to have her in their class. This was a incessant harming of his own daughter. And in fact, Judge Stokes says in there, between me and you, I care about your daughter more than you do. And so that was it was a problem that had to be addressed, and without addressing it, the result was going to be Madeline wasn't going to be in school for her senior year.
Thank you.
Thank you, Your Honor.
Thank you. Anything else? Okay, thank you. I believe you have 2 minutes.
Thank you, Your Honor. I want to be clear. There was no proof that Madeline suffered harm as a result of Exhibit 4. No proof that teachers did not want to teach Madeline as a result of Exhibit 4. The proof was that Madeline was a straight-A student, she was a lovely child, that she was doing well. Your Honor raises the exact problem, having to use the findings of fact, having to use other circumstances surrounding the case to glean from those exterior factors what the court intended is the problem. It was not clear. It was not unambiguous. Your Honor raises the next great point. What is a communication?
I don't think there's any question about what the order says. The order's not ambiguous. The order says what it says. The question is, what does the order mean?
The question is, what does the order mean? Is a communication with SBA mailing a letter to SBA, sending an email to the general inquiry inbox at SBA, sending a direct message to SBA's Facebook account, assuming they have one? The expert witness testified, if you want to communicate with someone via Facebook, the most effective way to do that is send them a direct message. The next most effective way to do that is to post on their wall. The next most effective way to do that is to tag them in your post so that they are alerted you mentioned their name. Mr. Wade did none of that. He posted to his public journal his feelings about child abuse, not about Madeline, not about SBA, about child abuse. If the court wanted Mr. Wade to be prohibited from referencing Sandra Morris, the court could have said that. If the court wanted to tailor Mr. Wade's First Amendment rights such that he cannot address a matter of public interest, child abuse, on his Facebook page, he could have done that. But he did not. He said that he's prohibited from communicating with those things about his child. He could have said Sandra Morris's landscaping is beautiful. He could have said SBA has a great campus. He could have said the Catholic diocese is better in Memphis than in Nashville. He was precluded from talking to those things about his child. And Exhibit 4 does not reference Madeline, does not reference his child. He has more than one child. So even if he was to say, my child, you would have to then infer that he was talking about his daughter, Madeline, which is the problem.
You've used your time.
Thank you.
Thank you.
I just wanted to remind the court, I did file the motion to consider post-judgment facts on December 8th, and so I will brief
Court's well aware
it.
of everything you filed.
Okay, thank you, Your Honor.
And the court will remind you, you have 10 days to file a supplemental brief addressing what effect, if any, the Court of Appeals opinion earlier rendered in this matter has upon the issue we're here today. We'll take this matter under advisement. We'll attempt to render an opinion at the earliest possible time. Thank you, counsel, and your